Y'all ever heard about James Brown? Y'all know who the Godfather of Soul is? Y'all know who that is? You know, he died one Christmas holiday. Do y'all remember that? Died over the Christmas holidays. Do you know that after he died, his body was there in his house for 90 days? They embalmed him, put him in the casket, put him in his house, and he was just sitting there. Do you know why? Why? What was the problem? He didn't have a will. Is that what you think? Well, here's a copy of his will. Let me tell you what the Godfather of Soul said, in part. The Godfather of Soul said, I have 6 living children. Deanna, Yama, Vanisha, Daryl, Larry, and Terry. These named children and any of their legitimate issue who shall also be lineage issue of mine shall be the entire class that I acknowledge to be my heirs and issue. Except as otherwise provided in this will and corresponding instruments, I have intentionally failed to provide for any other relatives or other persons, whether claiming or to claim to be an heir of mine or not. Such failure is intentional and not occasioned by accident or mistake. That's what the Godfather of Soul said in his will. He said, in other words, these are my 6 children. Anybody else popping up talking about something, I ain't thinking about them. And don't y'all think about them either. Well, it just so happened that one of his little background singers, Miss Tommy Ray Heine, had a child for him. And Tommy Ray Heine said, well, anyway, James, you know that you and I got married. And therefore, I am the one who should be in charge of your estate and your burial arrangements. Well, the children went and hired a lawyer, and they said, Tommy Ray Heine, we know that when you married our daddy, the Godfather of Soul, James Brown, we know you were still married to somebody else. So that marriage that you did is null and void because you were still married to somebody else. And therefore, the marriage you did to daddy is null and void because you need to get a divorce over there before you married our daddy. And although you married him, you needed to marry him again after you got a divorce from the other person. So Tommy Ray Heine, you just take your Heine on out of this courtroom because we ain't thinking about you. Well, Tommy Ray said, not so fast. I'm going to go to the appellate court because I ain't letting you just throw me out like that because I was married to him and I had a child by him. Well, the appellate court said, well, Tommy Ray Heine, maybe you were his wife because the man that you were married to, you married him to help him get his immigration papers. And we found out that he already had a wife back in the foreign country that he came from. So when you married him to help get his immigration papers, that marriage in the United States wasn't no good. So we don't count that mess you did to help him get no immigration papers. So you and James were married. Well, the children said, Tommy Ray, we don't care nothing about you and your man that you was trying to help get no immigration papers. You and Daddy had a prenuptial agreement anyway. And the prenuptial agreement said you agree that you ain't getting nothing. Do you all know that litigation has gone on more than 12 years? And the money that was supposed to be paid out, what James Brown wanted was for his estate money to be used to give scholarships to poor children who wanted to go to college. I don't know whether, as of this day, any child got a dime. Okay? They still having to fight.
They have money still to fight to pay the lawyer because the lawyer's getting the money.
Well, the lawyers are getting the money, but here's the thing with famous people who die. When Michael Jackson died, his accountant said his estate was worth $2,000. He was bankrupt, but after 2,000, not 2 million, 2,000. So then after Michael Jackson died, his image, his music, his records, his dancing and all that generated billions of dollars. So the estate is no longer bankrupt, and the IRS is now saying, where my part? Where my money? So these famous people, when they die, they could be almost bankrupt. But James Brown, his estate got a lot of money after he died, and people still play his music. And they still show him dancing. Same thing with Prince. Same thing with Aretha Franklin. So even if they were near bankrupt prior to death, all of their music and their creative works generate so much money that the family then inherits a problem with the IRS. So anyway, that was the saga of the godfather of soul, James Brown. You may not be famous like him, but the same kind of crazy stuff can go on with you as well. You might have a small estate, but difficulties and problems and surprises that people didn't know about because they assumed it would go one way, or what's fair in their mind tells them to act a certain way, and then when they don't do it properly legally, then there's a big, big problem. I have a book coming out in about 60 days called Make a Will, Do It Right, or the folk you don't like will end up with all your stuff. That's the name of the book. Okay? And yeah, that's the name of the book. So I want you to look at this one sheet that says Critical Estate Planning Concerns for You and Your Family. Look at this one sheet, and I'm going to tell you in a summary what I want you to concentrate on. And then after I explain to you what you should be doing in particular planning areas, I'm then going to tell you some of the worst calamities I've ever seen in those areas, because the things that I will share with you will highlight the most common mistakes I see in those areas. If the mistakes are common, then I assure you that there are some people in this room today that either did that or they're planning to do it that way, and they're going to run into the same problems. So what I want to do today is just kind of give you a summary of what you should be doing, and then I'm going to go item by item on this one-page sheet and explain to you some of the biggest, most common mistakes so that you can work around them. Now, I used to, when I did these seminars, I used to have like a 10-page handout, and it just kind of confused people. I learned over time that people want something simple and succinct that they can grasp real quick and get the key points so they'll have some direction. So if you look at this handout, I tell you there are 2 areas of planning. If you look at section 1, there are 2 areas of planning when it comes to life-death planning that you should be doing. You should be doing during life planning or incapacity planning, and afterlife planning or estate planning. Your during life or incapacity planning is the type of planning that says, I'm yet alive, I'm still breathing, and these are the things that I need to put in place for folk to help me if I'm still alive, I'm breathing, but I just need some help. Okay, the afterlife planning or estate planning is the type of planning that kicks in if you pass away and you want to let people know who's in charge of your estate, who should be getting what, who should be doing what. These are 2 different planning areas, and they are not the same. Okay, they are not the same. A lot of times people confuse them, and they say, okay, I got a power of attorney. And when somebody dies that gave you power of attorney, you run to the bank with the power of attorney and say, so-and-so died, I got power of attorney. I need to get $10,000 to pay for the funeral. And the bank says, I'm sorry for your loss, but the power of attorney died the day they died. So you have to understand, when you do 2 areas of planning, if you look at section 1, the 2 areas are incapacity planning and estate planning. Now look in section 2. When you do incapacity planning, the things that you will do include a living will, medical power of attorney, durable power of attorney, and a declaration naming pre-need guardian. These things work as long as you are alive. When you pass away, the things that you did under incapacity planning, they are no longer active. They become null and void. So you have to plan in both of the areas, okay? So now, The section 3, the basic estate planning, last will and testament, living trust, joint tenancy, Totten trust, life insurance. Now I'm going to explain briefly in a moment what each of those mean when I get to that section. But for now, I want you to understand there are 2 areas of planning you need to do. One does not suffice for the other one. You have to do the incapacity planning and you need to do the basic estate planning. Those are 2 separate areas. When you get your incapacity planning documents, they won't work for after you pass away. After you pass away, you got to have the basic estate planning documents in place if you intend for to have an estate plan that your family can work with. So now, let me tell you some of the biggest mistake areas so we can clear up some confusion and misconceptions and you won't get caught up in something where you're operating on some misinformation, because usually in this area, when you are misinformed, you find out when it's too late. You find out when the person who can change it is already gone. So then you have to live with the mistake, and the mistake ain't pretty sometimes. So now, look under section 1, the 2 areas of planning. What is the biggest misunderstanding or mistake that I see under section 1A incapacity planning? The biggest mistake that I see with incapacity planning is the power of attorney fits under incapacity planning. A lot of times when people have a power of attorney and somebody who gave it to them dies, they go and they try to use it. They go to the bank and try to use it. They try to do these various things only to find out that that power of attorney died the day the person who gave it to you died. That's the biggest mistake that I see with that one. Okay, what is the biggest mistake that I see with the afterlife or estate planning? One of the biggest mistakes that I see is this. So under estate planning, you see a last will and testament fits under estate planning. A lot of times people think if they have been appointed executor in a last will and testament, that authority extends to while the person is alive. Just like you can't use a power of attorney after somebody is dead, you can't use the authority given to you in a last will and testament before they die. So that's why I'm telling you, one set of documents does not extend over to the other phase of life. You have to get both. So now let's move down our list of items. Let's go to section 2, incapacity planning, the living will. The living will, one of the biggest mistakes that I see with the living will is people not understanding what it is and what it's for. People will call and say, I want to do a living will. Okay, a living will is a document that says whether you want to be on life support. It is not a document that says who gets your house, who gets your car, who gets your bank account. The living will says whether you want to be on life support. You notice living will is under incapacity planning, and you notice last will and testament is under estate planning. They're not the same thing. So when people say, I want to do a living will, I have to clarify with them and make sure they are not saying they want to do a last will and testament. So a living will is something that tells you whether you want to be on life support. Now, let's look at the medical power of attorney. The medical power of attorney is a document that states who can make medical decisions for you. Who is it that can talk to the doctor, find out what your medical challenges are, help make decisions for you and with you if you cannot do that on your own. Now, here is the biggest mistake that I've seen people make in that area. With the medical power of attorney, a lot of times when you go to your doctor or if you go into the hospital to have surgery or whatever, they will have you sign something called advanced directives, right? Have you all ever been asked to sign advanced directives and put somebody in charge and all that? Here's the biggest mistake that I see in that area. A lot of times when people come to my office and I'm explaining from this same chart what they need to do, they say, oh, I already did that in my doctor's office. Well, what's in your doctor's office is for your doctor in his office. You need to do a medical power of attorney with your attorney that's good for everybody. Okay, just because you got that on file in Jackson Memorial Hospital because you went there for something, then what if you get in an accident and you end up in the hospital in Tampa? They don't know you got something on file in Jackson because that's for Jackson. You need your own living will and medical power of attorney that can be accepted and used in any situation you go in. So don't just say, oh, I feel that out of my doctor's office. You need to have your own documents that your own people that you appointed and gave authority have a copy of. What you got in your doctor's office does not work for the other places you may end up for medical treatment. Now let's talk about the durable power of attorney. The durable power of attorney fits under incapacity planning, and it is a document that you give to people who will handle your business and financial matters if you can't. So now, this is extremely important, and it's extremely important that whoever you give durable power of attorney, you really trust the person. Because with these general durable power of attorneys, the person you gave the power can do anything with your stuff that you can do. They can go to your bank account and take money. They can sell your property. They can sign a contract and sell your property. They can go and change the beneficiary on your insurance. So when you give somebody durable general power of attorney and you give them that kind of authority, you really need to trust them, and they really need to be on your side and really committed to carrying out what you want. I've had people come to my office and say, I gave my brother durable power of attorney. He knew that I wanted him to just pay my monthly bills. He went and cleaned out the whole bank account and now won't answer my calls. So I looked at the document, and it was the latest signature. It was properly executed. And I said, well, you're going to have a real hard time suing him because nothing in this document that you prepared narrows him down to only paying your bills. That's another reason why you shouldn't do these things on your own, because if it's your intent to give somebody the authority to pay your bills only, but you went to Office Max, Office Depot, and you got a general power of attorney and gave them way more power than you ever intended, once you drag them in court and you testify that that's your signature, then you gave them the authority to do what they did. You didn't understand how to restrict the authority that you gave them. So one of the things about the durable power of attorney that's so important is for you to understand the power that you are giving a person. Now, here's another thing. A lot of times people will call my office and say, I need to do a power of attorney. My uncle is sick, my mom is sick, my aunt is sick, this one, that one, and I need to handle their affairs because they can't do this for themselves. I will say, are they alert? And do they understand what they're going to sign when I prepare this for them? They tell me sometimes they are, sometimes they're not. I will say, do they have a diagnosis of Alzheimer's or dementia? Well, yeah. Well, then how do I, in clear conscience, prepare documents and go to them and ask them to sign when you've already told me they have Alzheimer's and dementia, and I know they probably don't understand what you're doing? I say we are setting ourselves up for a terrible challenge. I said, is it anybody in your family that's going to be upset if you have durable power of attorney? Well, yeah, my brother's going to be upset. Or yeah, my sister's going to be upset. Or yeah, they already think I'm stealing mama's money or whatever. So if the person already got Alzheimer's and some lawyer go and help somebody go and get a durable power of attorney, and the first thing somebody suing the one who got power of attorney will hear is, you knew mama had dementia. You knew she had Alzheimer's. So while you're in your good mind, it's a good idea to get these things done. Because if somebody try to get it done for you and you are already beyond the point where you can understand what's going on, that's going to be subject to challenge. And everybody who understands that you had dementia and Alzheimer's will look very bad in the courtroom for doing that. A lot of times I just back out. I say, well, if I know this is going on, I'm not going to sit there in front of the judges, all of whom know me and I know them, and have my credibility on the line for going into a hospital and doing this when I know you already told me they have Alzheimer's or dementia. So one of the biggest mistakes with the durable power of attorney is waiting too late to get it done. If you got to get a power of attorney for somebody, don't wait until they get Alzheimer's or dementia, and you're going to be challenged and look really, really bad in court for doing this if you know they have any kind of mental challenges. Now, the last thing that I have on the incapacity planning, a declaration naming pre-need guardian. If in the future it's determined that you need a guardian, it's good for you to state right here, right now, I have a sound mind. This is who I would want if for whatever reason it's determined in the future we have to go to court and get a guardianship established and appoint a guardian. I'm telling you right now who I want. So these are all incapacity planning documents under Section 2, which indicate, when you choose to do these documents, you're saying, if I'm incapacitated, if I have a car accident and I'm in the hospital for 2 or 3 months, or if I'm, whatever the reason I can't function on my own, I'm naming in advance who I want to do it. Now, before I go to the next section, I want to emphasize these documents are extremely important to the healthcare professionals. They don't want to be in the hospital with a squabbling family trying to figure out who to talk to about your medical care. I can't tell you how many times I've been drawn into a situation. I had one situation where here it was 2 o'clock in the morning. A hospital administrator called me. I don't know how she got my home phone number, but she called. She said, I want to know who is authorized to go and see such and such and such a person. And I said, well, the daughter is authorized, and that daughter's son is authorized. I said, what's the problem? She said, well, the son is here raising all kind of hell. He's up there in hospice. His mom has only a day or 2 to live, and he's demanding to know from her whether she put him in the will. Okay, I say, well, the short answer to that is no. She didn't put him in because I prepared it. And he knows he's not in because I already gave him a copy. He knows that. But, this man was up there in the hospital raising all kind of sand. So one of the things that I started doing when I do these documents is listing who can't visit people. This is the first time that I started doing that because of these kind of calls. But now that situation was so bizarre. He was there. They called the police on him. The police removed the man from the hospital. Okay, then the mom passed away in 2 or 3 days. And instead of the man just release it, let it go, at the funeral, when the sister went up to take a final glance at her mother in the casket, this crazy man went up there and jumped on her. At the funeral. They had to get the police to pull him off of her at the funeral. The man scared me. I said, oh my gosh. I don't know how he's going to behave because I handled the lady's estate. So we had a hearing. We were getting ready to have the final hearing, and he was getting ready to hear for real. You really ain't going to get nothing. I didn't know how the man might act because I know he'd already jumped on his sister. I knew that part. And I'm like, oh my gosh, do I need this? I wrote the judge a letter and I told the judge, I said, in an abundance of caution, I need to advise you of the animosity in this family. I need to advise you of a particular beneficiary who is so enraged that he actually attacked his sister at his mother's funeral as she stood in front of the casket. I want to tell you about this. I don't know how. I said, now, whenever the man has called my office, he's always been very professional and very courteous. But at this point, when it becomes real that, yes, your mother gave 2 properties to your sister and not 1 to you, When that becomes real and final, I don't know. I said to the judge, I think we need police presence in the hearing. We had police officers outside the door. Now, all of the judges have a button underneath their desk where they can press the button and call for help. The man came to the hearing. He was quiet as a church mouse. He didn't say anything. The judge gave his verbal order about how the assets would be distributed. At the end, after the judge gave his order, the man held up his hand. Your Honor, can I say something? The judge says, yes, you may. He said, are you telling me my mother didn't leave me nothing? The judge looked at him with all calmness. That's correct. I said, thank you, Your Honor. I gathered my briefcase and went out the door and hope I wasn't going to feel a foot in my butt. He was quiet. That's all he did. He asked one question. When the judge answered the question, we gathered our things and we went out of the hearing, and that was that. You know, sometimes people fight at the courthouse, but he was calm. So anyway, so back to what we're saying, 2 areas of planning, incapacity planning and basic estate planning. But under incapacity planning, if you would do those documents, the healthcare professionals will be so happy if you will if you'll get that done. Ms. Jenkins, I got 5 more minutes. Is that what it means? I got 6 minutes. Okay. I'm going to tell you some key things. All right. If you look at Section 3, Section 3 gives you the basic things that fit under basic estate planning. A last will and testament, a living trust, a joint tenancy, a Totten trust, life insurance. Now, the last will and testament says who you want to get your house, your car, whatever you have. The living trust is a more sophisticated document. It can transfer assets too. If you're a person who doesn't want to go to probate court, then you need to do a trust. Okay? Now, let me tell you some key things about the living will, the last will and testament, Section 3A. The last will and testament, people often misunderstand that if they do a last will and testament, they got to go to court. A lot of times people say, well, what do I do a last will and testament for if my family got to go to court? If you do a last will and testament, your family got to go straight to court. The purpose for doing a last will and testament is not to keep them from going to court. It's for the court to understand how you want to distribute your assets. So if you somebody that don't want your family to have to go to court, then you need to do a living trust. Okay, a living trust is much more sophisticated. Do not try to do a living trust on your own. Don't go to LegalZoom or wherever people be going, because I've seen the worst catastrophes. Don't do it. You don't understand what to do. Okay, now, the joint tenancy. Yes? Somebody's asking a question?
Yeah. No.
Not yet. I think she got a little time segmented for that.
I have a question.
Hold your question.
Question to the end. 1 second.
At the end, we're going to get there. Don't forget it now. All right. Joint tenancy, Section 3C. A joint tenancy is a deed where if you know you want to give a particular person your property, you put their name on the deed. Most laymen who do not practice law don't know how to phrase that. The phrase, so that you will keep the person from having to go to probate, is joint tenancy with right of survivorship. Don't do it. Don't go try to do that on your own. If you mess it up, you're going to create the wrong kind of ownership. But if you're trying to give property to somebody such that if you die, they don't have to go to probate, it's called a joint tenancy with right of survivorship. The Totten Trust 3D is a bank account. If you got money in the bank, go as soon as the bank opens and list a beneficiary. If you list a beneficiary, all that beneficiary needs to do is go to the bank with the death certificate after you pass away and get the money. If you don't list the beneficiary, then your family is going to have to open probate in the probate court, and some of everybody, the lawyers and the creditors and everybody, they're going to get the money. But all you got to do to prevent that is go to the bank and name a beneficiary. If you do that, then the money in the bank is not even considered a probate asset that the court rules over. So you need to do that as soon as the bank opens and as soon as you leave here. Okay, life insurance, we all know what life insurance is. One of the things I want to tell you about life insurance before I tell you another big matter before my 6 minutes ends. With life insurance, do not put minor children on the life insurance. Don't put minor children. If you want to provide for minor children, you need to do a trust and put the insurance proceeds in trust, and you spell out in your trust agreement how the children are supposed to use the money. But do not put the minor children down on the life insurance policy. Otherwise, if you pass away and they're still minors, you're going to create the need for guardianships, and guardianships last until the child is 18, and they're very expensive. You're paying your lawyer every year if you have to open up guardianships. You're really losing money. So do not put those minor children on your life insurance policy.
Or I can be the guardian and steal the money.
Or she can be the guardian.
Right.
Now, one last thing, which I get a whole lot of facial expressions from this one. In this day and time, people marry later in life. People remarry. Some people have been married multiple times. If you have property that you bought before you met the love of your life, and it's your property, or you bought it with the first husband, or whatever, once you marry a person in the state of Florida, the homestead law says that property belongs to the one you married. Okay, never, he ain't got to be on the deed. She ain't got to be on the deed. You can write a will and say, I bought this with my first husband and I wanted to go to our children. None of that matters. So understand, if you got homestead property and you just met the love of your life and you say, well, his name ain't on the deed, it doesn't matter. The minute you said I do, he just inherited that property. Okay, he doesn't have to be on the deed. All right, he does not. You can write a will and say whatever you want to say in your will. That's his property. The only way to fix that is for you to do a prenuptial agreement. She says I got 1 minute. I wanted to tell you all that because a lot of times when I say that, especially, in women's groups or women conferences, I'm like, I had one lady stand up and jump and say, what? I say, yeah. And then a lot of times when people are already married, they can sometimes go and do a postnuptial agreement. But when you do those agreements, the law requires, let's say I write it up I tried to do this after the lady was already married. I wrote up the agreement for her. I represented the wife. She couldn't get her husband to sign. He's like, you want me to sign my rights away? No. So you have to think about that before you go down the aisle. And you have to have these conversations before that time. So look at your document. 2 areas of planning. We're wrapping it up. You got a checklist of things. When you go to your lawyer, don't just go up and say, I want to do a will. You need to discuss everything that's up here. Now, in about 60 days, I have a book coming out. If you want to know all the questions you need to answer about all these specific areas, I have a chapter on each one. And I have some stories, real life stories like what I just told you about. Thank you for listening.